Hey there, everybody. Welcome to the next episode of the Justice Revolution. Happy St. Patty's Day to you. Top of the day to you all. That's my terrible accent.
That was horrible.
My wife always makes fun of me because I'm terrible. My Irish accents. That's
I love it
because
that you
I
just
don't have any
do
Irish
that,
heritage.
though. Yeah.
I don't have any Irish heritage, none whatsoever. But anyway, glad you guys are here. C to AZ, Freeman Learning. Thanks for being here, you guys. Appreciate you. It is Friday, March the 17th. Like I said, St. Patrick's Day, the year of our Lord 2023. I'm your host, James the Patriot. I have my co-hosts, Erica and Justice. Say hello, you guys.
Hey, guys.
We have back with us our special guest, Adrian. If you guys remember from our show last week, we spoke with her about her situation. So thanks for being back, Adrian. Appreciate you being here.
Oh, thank you.
Oh, you bet. I'm glad to have you here. So today's show is we're going to do some interactive stuff. I'm going to actually do live screen, walk through a motion. Well, technically it's a motion to dismiss. However, since Adrian's already filed an answer in her case, it's going to be a motion for judgment on the pleadings. So we'll talk about that here in a second. But before I get to that, I do want to talk about a couple of other things. Real quick, let's get a quick update from everybody. Erica, what's new in your world there in your beautiful slice of heaven called Indiana?
Well, right now I'm working on it's tax season, right? And
Oh boy.
so remember everything. This is all this freedom stuff and realizing the veil of lies and deceit that we've been under our entire lives is all fairly new to me in the last couple of years. So this is the first year that I'm actually doing something about, getting into that whole realm. This is the time of year where we're supposed to be filing our taxes. I've never felt right about it. Every year I'm like, this is icky. Everything feels wrong about this. Every time I've ever filled out a W-4 or like with a new job, I'm like, what am I supposed to put? Am I subject? What am I withholding? What's a withholding? Mm-hmm. Like I've never felt right about it at all in my spirit. And now I know why, because I read this really great book about the truth about the taxation in America. It's called Cracking the Code. Mm-hmm. And it just became very, very clear to me that unless you work for the federal government, you shouldn't have anything being withheld from you. Yeah. And why is that still a thing? Because that's from 1862. Like, have they not figured out their debt situation by now? I don't know. It just seems...
Well, because they can get away with it. That's why it's a thing.
Right. They keep lining their pockets and everybody keeps going along with it every year. So I'm just going to start spreading the word with everyone I can to withdraw. Like, if you don't work for the federal government, then just get out and stop paying. Stop having them withhold your taxes. I mean, thousands and thousands of dollars they've withheld. Yeah. Robbing us blind. Weird.
Yeah, we could spend a whole show on this. We really could.
We should.
I think we should. It's tax season. We really, really should.
Yeah, we should, and we could talk about some of the things that we've found. But you're right. At the end of the day, we've all been. I mean, for lack of a better term, we've all been misled. We haven't been told the truth up front. You've just been given this form from your employer and say, hey, you need to fill this out. And so you just fill it out. Yep. But you don't realize what you're doing. So we're going to talk about that. We're going to talk about the tax code, which is it's Title 26, United States Code. There's been speculation how that code hasn't been enacted into positive law. You might have heard that before. At the end of the day, that's not true. So people have been prosecuted under those laws. But you also have to realize if you're being prosecuted under those laws, it's because you agreed to be into that law, if that makes sense, which we'll talk about that on another show upcoming, obviously soon, because you're right, it is tax season and people are going to have some questions on that. So good on you, Erica. Yeah, that's a great read, Cracking the Code. You can find more information about that at a website called losthorizons.com, I believe. losthorizons.com. Let me double check that.
Got it.
I'm pretty sure that's what it is.
Yeah, it's losthorizons.com.
Okay, good. losthorizons.com. There's some good information there. Also, just remember, nothing that we say in this show is legal advice and should never be construed as legal advice. And if you take it as legal advice, please have your head checked. Okay, let's get that out of the way. I can see Adrian's over there laughing, and I appreciate your I appreciate your humor. So, Justice, you've got some interesting things going on in your life. Care to share?
Well, besides my house being torn apart because we live in the mountains and everybody up here has gotten an immense amount of snow this year because of climate change and global warming.
Yes.
And due to the global warming and all the extra snow we've had, my house is leaking, so they're tearing it apart to mitigate mold. So it is a big, big, big byproduct of global warming, extra snow, just so you know.
Yep.
And we've got some great prospective win coming up with our mortgage case. We found a great guy he's a private eye. He's been doing this for years. Pulled him into the mix. He said he could help us out. He found proof of fraud, and it's exciting. So we're getting ready to land that lawsuit in just a few days, I think, early next week. So that's
sometime next week. Yeah, he needed a couple of days to finish up his investigation. He said he's going to hopefully be done with it by the end of the day today. So really exciting to see what he comes up with, and then I'll be able to take that information and incorporate it into the lawsuit that we're going to be filing next week. So along with our civil RICO case, which is really where you stick it to them.
So everybody pray, because prayer is so powerful that this comes through, because when it comes through, not if, but when, we can then help so many people. There's so many people in the same situation. So that's our goal always, that we've said from the beginning, is we just want to, we're not after not paying anything that we're supposed to pay. We're not after trying to get out of or escape from anything unlawfully. We're just out to hold the people that are hurting other people accountable, criminals that are hurting you deceitfully, knowingly, which is the RICO part. That's our goal. And when we accomplish that goal, we will help others with our platform here. So that's the exciting part for me.
Yeah. When it comes to mortgages and home loans, it's amazing the shenanigans these people pull. Probably the best term. I was talking with this private investigator more. I won't mention his name just yet because we haven't asked if it's okay to share his information. But I was texting back and forth with him because I recently, I told Justice, you guys know, I recently refinanced my house, and I was reviewing my trust deed, which has my promissory note on there, and I found some interesting things. And so I started asking him about it, and he said, no, it's as long as you're current on your mortgage, you're fine. What happens is, like, if you get behind on your mortgage, that's where the shenanigans happen. So, like if you get behind 1, 2 or 3 months, and then they refuse to accept a payment from you, like what happened with Justice.
That never happened, though. We never got behind.
Exactly, which is what's crazy.
Yeah.
Which is what's absolutely crazy. So that was before you never got behind that time. And then you called to make a payment. They refused to take your payment.
Well, the only thing we got behind it. So what they do is they try to exhaust you like everything else. And they make you fill out to get a loan modification. We had a marketing company. And in 2008, when everything crashed, nobody wants to buy marketing anything. Yeah. So, for safety's sake, we said, well, let's see what we can do. Just like with the coronavirus. Let's see if we can put some things off, get some forbearances, do whatever.
Sure.
Why the big banks get to stay in business in crisis is beyond me. I don't know. So we said, let's look into a modification. And in this process, what they do is they make you do paperwork over and over and over. So it was one specific piece of paperwork, which we have it in writing somewhere, that just didn't get updated. We were like a week late or 2 weeks late. And in that period of time, they swooped in like vultures and would not. And we never missed a payment, mind you. Never missed a payment. And they would not let us make a payment from that point forward. And what we learned was that's because in 90 days, the insurance kicks in. So it's just it's such a big mess of corruption. It's not even funny.
Yeah. Yeah. So anyway, it's amazing where it's coming, but we're really excited to see what this private investigator comes up with. Freeman Learning here says, got this going on with my mortgage. I need this guy to investigate. Yeah. Reach out to us on in our Telegram group in Affidavits 101 Freeman. We'll be happy to pass along his information. Super good dude. And he's straightforward. So I think you'll, matter of fact, Randy Kelton recommends him. So if Randy recommends him, then he's above board.
That's great. I didn't know that.
So,
Thanks for sharing.
Yeah. Just found that out. So,
Okay.
All right. Well, shall we get to the meat and potatoes of what we're going to talk about today?
I think so.
I think we shall. So, Adrian, welcome back. How's your week been since we last spoke?
Pretty mild.
little
Trying
more
to partners in the law firm to do that bar grieve.
Oh yeah. So we were chatting back and forth on Telegram. You were figuring out who to bar grieve and where to bar grieve. So
yeah, this company they have multiple branches, and so the way that there was a lot of back and forth to verify, and I can only find 2 partners that are consistent through multiple branches plus the lawyer that did my thing. So
okay.
So I did the 3. I don't get the huge amount of bar grievances I was hoping for, but 3's better than none. So
Yeah, 3 is better than none. So
1 is better than none.
Amen. Amen. So all right, so let's get into what we're going to talk about today. So we mentioned how Adrian was served a lawsuit, and she reached out to the entity that was suing her and said, "Hey, I'll set up a payment plan." They said, "We're going to sue you anyway." Okay. So she filed an answer to their suit and just denied everything. So now where we are, you guys, is you need to understand what happens in this process. And the first thing I want to do is I want to start off with, what do the court rules say? So let me open up my screen, get to where I need to first and foremost. Sorry, I should have had this prepared ahead of time. UT courts. All right. Okay, so what we're going to do is we're going to go to the court rules. And let me share my screen for those of you who are watching, and for those who are not watching, I will talk through everything I'm doing. Okay. So let's see. Are we shared here? Yes, we are. Okay. So what I do here, since Adrian lives here in Utah, and she's being sued in a district court of Utah, we're going to go to the court's website to find the applicable rules. So they've changed things up on this website recently, which is annoying. But the way I found it was under legal help. And then here there's a drop down that says court rules and procedures. So I click on that. Then the next page that comes up is it brings a few different things here, taking a case to court, motions, what are the different types of motions there are. These are the most common types of motions that are used, and so that's why they're here. But I want to go to the court rules, which is the third one down. And since this is a civil case, we are going to go to the rules of civil procedure, which is the first one. All right. So these are the rules that govern every single action that is commenced in a district court, or any court for that matter here in Utah, under the civil cases. So there's part 1, there's part 2, there's part 3. Every single one of these rules has an accompanying number. What's nice about most state rules is they do tend to mirror the federal rules. So for example, federal rules, Rule 12 is defenses and objections. Here in Utah, Rule 12 is defenses and objections as well. So there might be some small differences, but for the most part, they're the same. So now what I do is I go, okay, Adrian was served. She filed an answer. So what do we do now to get this case dismissed? And this is the question for you guys. So for Erica, Justice, or even you, Adrian, what would you think we would need to do, knowing after we went through your case last week, the fallacies in this case? What do we do to get this dismissed? Where should we look?
Motion to, let's see.
For judgment?
Yeah. So what I would do is I would go right here to Rule 12 under defenses and objections, and let's see what rules are in place to allow us to object to this. So you've already filed an answer. right here under Rule 12B, there are 7 different actions that you can take before you actually file an answer. So if you're going to object to the court having lack of jurisdiction over the subject matter, you're supposed to do that before there's an answer filed. However, subject matter jurisdiction can never be waived. Now, you can waive your lack of jurisdiction over the person, which when you filed your answer, you did. You can waive the improper venue. You can waive the pleader must be made by insufficiency of process, insufficiency of service of process. You can waive all of those. However, as we've been talking about in our past episodes, right, Erica?
Right.
Subject matter jurisdiction can never be waived. So in that case, you've already filed an answer. So what should we do now? What do you guys think if we're looking at these rules on the screen here?
Motion for judgment on the pleadings.
There you go. Right here. So let's read this rule because this is the rule that's going to help us know if this is appropriate. It says, motion for judgment on the pleadings. After the pleadings are closed, but within such time as not to delay the trial, any party may move for judgment on the pleadings. If on a motion for judgment on the pleadings, matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment and disposed of as provided in Rule 56, and all parties must be given reasonable opportunity to present all material made pertinent to such a motion by Rule 56. Okay, Rule 56, that is the motion for summary judgment, which is down here. Rule 56, summary judgment. Okay? So, you guys now remember that side of it. Do you guys remember some of the issues that they had in their case when we were looking at this last week? I'm going to pull up.
The lawyers were bringing the claim, right? There was a lack of standing.
Yeah, I'm going to bring up this complaint again so we can go over this to see some of the issues. So the first issue we noticed is that the plaintiff or the alleged plaintiff here is Portfolio Recovery Associates. That's who's named as the plaintiff. All right. Now I'm going to go back to, all right, geez, I'm just going to share my entire screen because this is annoying me. Entire screen. Let's just do this one. All right. Okay. I'm going to go back here to this screen. Under Part 4, it states parties. Parties, plaintiff, and defendant. So this is Rule 17 of the Utah Rules of Civil Procedure. Let's read this. Erica, are you able to read A right here for us? Can you see that?
I think so. Real party and interest. Every action shall be prosecuted in the name of the real party in interest.
You can just stop right there.
Yeah, that's
okay. So what does that mean?
That means that they're collecting for the real party of interest.
Well, who is the real party in interest?
That's the question, because we know collection agencies aren't the parties of interest. They're hired.
All right, so
parties of interest.
So we know what the real party in interest is. It is a real party in interest is a party that must be able to claim and prove damages. Right?
Right.
You've got to be able to say, hey, Adrian as a defendant, she did this, and as a result, I suffered this type of damage. All right. So according to the complaint, it states here the claims are that she resides in the county. Okay, that's fine. We got no issue with that. Defendant opened an account with Synchrony Bank. The account was stated by and between Synchrony Bank and defendant, wherein it was ascertained at the closing of the account that said defendant owed $1,200. Okay, so based on what they're saying right here, Synchrony Bank is the real party in interest. So why is their name not right here under plaintiff?
Right.
That's right. Yeah, I remember this.
Right? Portfolio Recovery Associates has listed nothing in their complaint that states they have they have been harmed at all.
Right.
I don't see anything. Unless
That's
I'm
so interesting.
Yeah, unless I'm missing something. You guys
No.
see anything here? Because
Mhm.
yeah. So here's how we're going to pick this apart. I'm frustrated because I downloaded a document yesterday and now I can't find it. And I wanted to pull it up on the screen to show you guys. I know. I'm gonna have to do a search here again and see what I can come up with while we're talking. So, but anyway.
So often, James, like even with my suit, it was the same thing. We had to go back and forth numerous times to actually find out who the real party of interest was. Because
Yes.
it started with Shell Point, which who knew where they were, and then the lawyer got involved, and I said, you have any interest in this? And they wouldn't do it. And then finally, after 4 or 5 back and forths, it came up this U.S. Bank and Trust or something, and it turned out they are not even truly the party of interest as well. So
this is just what gets me so much about the tax stuff, about this kind of stuff. You can read something at face value, right? Adrian, how many times did you read that complaint that they brought up? And did you ever think, oh, well, they're not the ones who bring the claim? It's just our ignorance on it. It's like we don't even know what we don't know to read something that is so obvious to someone who knows it. So how could we ever be expected to even know that it was a thing? So it's like
we put our faith.
I just know I have a summons and now I have to answer it.
Well, we put our faith in people that we think are looking out for our best interests, and they're not. What they're really doing is taking advantage of us. Because you want to be loving. We're called to be loving humans and help one another, and you assume that's what a lawyer is doing for you or anybody else, and they truly are not, which is the big revelation in these last few years.
Yeah.
Disturbing revelation.
Yeah, and it is a disturbing revelation for sure. So let me see if I can find, actually, let me do this. So I subscribe to, one of the services I subscribe is from Thomson Reuters. And it is the federal forms, which is not, I like it because these are the forms that attorneys use. So, and they have a lot of just basic stuff here. So let me pull this up here. Cause again, the way that I write documents is I find a document that somebody has written and I look at it and go, hey, this is great. I'm going to take this. I'm going to take this. I'm going to take this. And so I want to give you guys just a brief overview of how I do things. And then you guys can see, where is it?
James, I think I posted a link to some forms going back in connection with our actual annotated statutes from the early 1900s in Utah.
Yes, I did see that. Yes.
Which stands as law. So anyway, if that's helpful to anybody out there, which has been recommended to always read the annotated statutes, which are old, and you have to search for your state.
Yeah, that is true. I mean, and that's absolutely helpful, and that's something you guys should all do. God, I can't find what I'm looking for. This is driving me crazy. Anyway, I'll go to another site here, another spot. So let's pull up.
Someone asked you to repeat the forms from the site.
Or the form site. Yeah. So it is. I'll share it on my screen so you can see it. C to AZ. So, whenever I can get my stupid screen share to work here, and then I'll mention it again. Oh, let's go window. Let's go here. Okay, so there's 2 different places you can go. So I'm subscribed to Westlaw Classic from Thomson Reuters. This is not cheap. It's about 300 something bucks a month, but I do it because I can find all sorts of stuff. I was looking earlier for a motion to convert a motion to dismiss into one for summary judgment, because that's something I'm going to do in another case I'm in. However, for today's sake, let's go back to this screen here, and I'm going to go back to the search screen, and I'm going to look for motion for judgment on the pleading. Sorry, I was just typing that out for those of you who are listening. Oh, actually, there's one right here. So let's just get rid of this and then hit search. Okay, so what I love about this is every single civil trial document that's been filed. I mean, gosh, there's over 10,000. Let's look and see if we can find one for defendant's reply brief. Actually, let's go. Let me go back, and I'm going to add the word defendant in here. So that way we can find one that was filed by a defendant. This should give us a good idea of what one of these documents looks like. Reply brief, response, reply to plaintiff's brief. Okay, why can't I find? I just want to find one that was filed by defendants. My gosh. Judgment on the pleadings. You know what? Screw it. We'll just go to a plaintiff's evidentiary objections. I just want to find one that a plaintiff or a defendant has filed that we can look at for reference. Plaintiff's reply brief, defendant's reply brief. These are all reply briefs. I don't want reply briefs. I want the actual motion. What's irritating is there's another site that I go to. It's called Scribed. You guys have heard of that website?
Yeah.
Scribed. Here's the problem when I try to go there. Scribed.com. It keeps giving me, unless it's working now.
Do you have it saved somewhere?
Oh my gosh, look at that. It's working now. I tried to log in here earlier and it wouldn't let me. So I need to log in here real quick. Oh, I'm still here. Good. So I'm going to look defendant's motion for judgment on the pleading. See, I was here last night or yesterday looking at this. Their website is weird in that sometimes it works and other times it doesn't. So let's go to view more documents. What I like about this website is I can search again for anything like this. So here's one right here that somebody uploaded. Oh, this is the one I was looking at. So let me download this PDF document, download the document. Okay, there we go. All right, now I have what I want. Sorry that took so long.
Okay.
Let me stop sharing that, and then
I think it's helpful to see the process of the searching because I spend a lot of my time just trying to figure out where to find what I'm looking for. So it's helpful for me if that's
it's like a workshop, which is great.
Yeah, well, I'm of the opinion we don't need to reinvent the wheel here, right? And somebody else has already done this. Let's find something that's decent, that looks good, and let's just copy it. So. All right, let me go back and I'm going to share my screen again, a couple of other windows. Let's share this one and, oops. I wonder if it'll let me share multiple. Oh, it won't. Dang it. Let's just look at this one. Okay, this is the motion for judgment on the pleadings. You don't need to go this crazy. This is a 24-page document. They've got this table of contents. They've got all of these things here. They have the table of authorities of all their cases. I'm just here to tell you guys as pro se litigants, you don't need to worry about all of this. You can if you want. It makes the document easy, but you don't need to. So what I wanted to get to here, and I'm scrolling down fast, I want to get to the meat and potatoes. Okay, here's the motion. Pursuant to Rule 12C. Okay. So guess what in our document, we're going to say pursuant to Rule 12C because they're identical in Utah. We're moving for judgment on the pleadings. As demonstrated below, plaintiff's complaint fails to state a claim under whatever claim they're making. As a result...
Free roaming horses. Oh,
yeah.
Okay. Oh, James froze. You froze, James, if you can hear me. Reboot, James, and pop back in.
Yeah, this is wild free roaming. And anyway.
Okay, James, you're freezing.
All right. Sorry about that, guys. My Wi-Fi just went crazy.
Yeah, you were freezing. So repeat whatever you just said. After I said wild roaming horses, you went blank.
All of a sudden, everybody, you gotta love internet these days. Anyway, so we're gonna skip all of this stuff here. We don't really need to worry about the introduction part of it. You can put an introduction into your stuff if you want, but I'm just here to tell you, in these smaller courts, less is more. So all we want to do is we want to get back to, I want to get down here to the legal standard, which is coming, I promise. Here we go. Argument. Okay. So in Adrian's document, you're going to have a brief introduction that's going to state what we're doing. We're moving the court for judgment on the pleadings because of this. You can put a brief introduction if you want, to something that states, plaintiffs filed this complaint. However, plaintiff's complaint does not state a claim for relief. In fact, plaintiff's complaint states that the real party in interest is so-and-so, not plaintiff. So we're just taking information from plaintiff's complaint and we're just shooting holes in it. Mm-hmm. So I wanted to show you this document here first, but what I'll do is I will stop sharing that screen and I will open up the actual document and we'll start writing this up, shall we? Right here.
Adrian's like, oh yeah.
Yeah.
I'm all excited.
Workshop people.
Yep.
Yeah.
Okay, so here's how the document should look. You're at the top, you're going to have your name, you're going to have your address and contact info here. For obvious reasons, I didn't put that in here. For one, I don't know it, and for two, don't need to be advertising Adrian's address.
Yep.
This is called the caption portion of the document, where we list the name of the court, the plaintiff, the defendant, what the document is, motion for judgment on the pleadings, the case number, and the judge. I don't have that information. I'm sure you probably do, Adrian. If you can find it, don't worry about it. Don't worry about it. I mean, I'll send you this. You can fill that out.
Okay. I'm like, it's literally right over there in another part of the room.
Oh, if you want to go grab it, that's fine. If it's that close, that's totally fine. So let me just read what I came up with. I took the liberty to type this up ahead of time, just for sake of time. So here's what I put. I said, defendant Adrian Buchanan Asplin, herein referred to as defendant, moves this court for judgment on the pleadings pursuant to Rule 12C of the Utah Rules of Civil Procedure against plaintiff Portfolio Recovery Associates, LLC, hereinafter referred to as plaintiff. As demonstrated below, plaintiff's complaint fails to state a claim for which this court can grant relief. Additionally, plaintiff's complaint fails to invoke this court's jurisdiction over the subject matter of the complaint. As a result, defendant respectfully requests that the court dismiss all of plaintiff's claims with prejudice. Pretty simple, right?
Right.
So you guys remember the next thing that we're going to do is we're going to go and we're going to go down a little bit here. Now is where we're going to put just a brief introduction. So let me just go here and let me go bold and underline, and we're going to say introduction. Whoops. I can spell it right. And I'll make that a little bigger. Okay. All right.
Where did you find the blank form?
What blank form? This one here?
Yeah, with the format that you're using.
I had to create it myself. So, okay. So what I will do, to help you and to help everybody else, again, I'll post this as a Word document in the Telegram chat, and then anybody is welcome to use it. So, well, I'm going to go down a little bit here. I'm going to come here.
So, James, the party of interest is the party you contract with.
Correct.
So if someone else is trying to collect on someone else's contract, I'm just trying to put it in simple terms. So
they have no authority to do so.
Yes, just like someone else couldn't come after you for a personal loan or a car loan if you're not contracted with them, which it seems to be most of these bill collectors. It's almost illegal the way it appears.
Mm-hmm. Yeah, I mean that's the frustrating part.
Anyway.
Exactly. Yeah. So like I said before, all they've done is they've just purchased evidence of a debt. They didn't actually. It's absolutely right. I mean, you have no contract with them. Now, sometimes these contracts will say that we reserve the right to sell this to somebody else. This isn't like going to the doctor or hiring somebody to come to your house to do something for you and then you don't pay them. That's different. If you go to the doctor and you don't pay them, they can absolutely send your information over to a debt collection firm to collect on their behalf. That's totally fine. What I'm taking issue with this is you tried to make it whole with the original creditor, and then they just like, yeah, well, we're not going to work with you. And so they just turn around and sell this to somebody else for pennies on the dollar. Now somebody else is trying to collect the full amount. I mean, you guys can imagine they probably bought this, like they're saying there's $1,200 owing. They probably bought this for like $200 or $300.
Yeah.
So like Synchrony Bank sold this to Portfolio Recovery Associates for like $200 or $300. Now they're trying to recover the full amount, but they have no standing and they have nothing that they can do about it. So,
and wouldn't the original creditor have insurance to collect this anyway?
Exactly.
Yes.
So
they charged it off. Yep.
Yeah, 2 or 3 times what they. Yeah.
Yeah, they charged it off.
So does that phrase "fails to state a claim" encompass all of what you just said about how they don't have? Okay,
yeah.
I just wanted to state that.
It does, right? Because again, you're bringing a controversy before the court. You're asking the court to settle that controversy because you're saying, hey, we stated a claim, but wait a minute, no, you don't have standing. Oh my gosh, there's that term again.
Mm-hmm.
You don't have standing. So here's what we're going to do. We're going to put in a brief introduction. So of why we're seeking a motion for judgment on the pleadings. And I'm just going to go along something along these lines here. We say plaintiffs. Actually, I wonder if I can just talk and text at the same time. It might actually be faster. Plaintiffs. Let's just see here. Plaintiffs have requested from this court.
Now it's just my name on there. Do I need to add my husband's, even though he's not like part of other than him?
No, it's whoever their summons named, and they only had your name listed. So plaintiffs have requested from that. Let's see. From this court, relief in the amount of, let me see what it was. Or did I close it? Dang it.
$1,172.
$1176.01 in the amount of 1176.01 plus attorneys. I can't see. This is what's so hard for me, guys, when I'm doing this live, because I make all these mistakes. I just go back and fix it later.
It's fine.
Plus attorneys' fees and any other costs this court deems appropriate.
This is why we proofread. It's all good.
Yes.
I'm the queen of typos, so as you know, James, I don't go bach and fix them. So
we know that because we had one of our guests who was misnamed. Oh, it was funny.
That was funny.
So, let's see here. Plaintiffs have requested from this court relief in the amount of 11 plus attorneys' fees and any other courses deemed appropriate, stemming from an alleged overdue balance of some type of credit issued. All right for now?
Yeah.
According to, whoops, come on now, fat fingers, work with me. According to plaintiff's complaint, defendant opened an account with Synchrony. I can't spell again. Here we go. Synchrony Bank on or around. Sorry, I got to find my reference points here again. On or around. What does it say? It doesn't say. We're just going to say Synchrony Bank with an account ending in 9789. Additionally, plaintiffs allege that when the account was closed, there was an amount owed of $1,215.01. 0.01. The complaint alleges that the account was then, I'm going to put this in quotations, assigned to the named plaintiff in this case. The complaint additionally states that the account was charged off for the amount of $1,215.01. Okay, what do we think so far?
On there
Was it in that order? Did they charge it off first and then assign it to?
According to the complaint, it says Synchrony Bank assigned the account to plaintiff. The amount charged off on the account was there is now due and owing to the plaintiff the amount of $1,100 less any payments made.
Okay. I don't know how the whole order of things works out. If they charge,
it doesn't really matter. Again, they have not. All they've done is they just put in a complaint. There's no evidence verifying any of these claims. There's no evidence. So all they just state that Synchrony Bank assigned the account to plaintiff. Okay, well, where's the evidence? Additionally, where is any evidence that Synchrony Bank is even aware of this action? Right?
Oh, that's a good one.
Do they even have a clue what's going on?
Yeah.
I seriously doubt it. So let's just read over this again, just make sure it makes sense. Plaintiffs have requested from this court relief in the amount of $1,176.01 plus attorney's fees and any other costs this court deems appropriate stemming from an alleged overdue balance of some type of credit issued. According to plaintiff's complaint, defendant opened an account with Synchrony Bank with an account ending in 9789. Additionally, plaintiffs allege that when the account was closed, there was an amount owed of $1,215 and a penny. The complaint alleges that the account was then assigned to the named plaintiff in this case. The complaint additionally states that the account was charged off for the amount of $1,215.01. Okay, so how do you think we guys should finish out our introduction?
Asking for a
There's no, just what you said, there's no evidence.
Yeah.
No evidence has been provided.
Yeah, so
unless that's for a different section.
Yeah, we're going to say, based on this information above and the allegations taken from plaintiff's complaint. Come on. Based on this information above and the allegations taken from plaintiff's complaint, the rule of, well, I don't know if I want to go there yet. Let me just see here. Okay, based on this information above and the allegations taken from plaintiff's complaint, the plaintiff's complaint fails to state a viable claim in support of their request that this court grant their claim for relief for the reasons listed below. Okay? So our introduction is done.
Great.
Okay, so now we're going to go into our argument, and we're going to say why. Why does their complaint fail to state a claim? So let me change this and go to argument. Is that right? No, there's no E there.
Yeah, you're right.
Argument. Okay. So here. All right. So now what I'm going to do is I'm going to take, and this is where I come in and go, okay, I'm just going to copy and paste a bunch of stuff from this other complaint that I found. Make life easy for us. I go down to 12 point, and it's going to be a 2 double spaced. We're going to go there. Okay. I'm going to change out a few things. Under the Utah rules of civil procedure, after the pleadings are closed, but early enough not to delay trial, a party may move for judgment on the pleadings. That's going to be UT rules of civil procedure. Dismissing a case based on the pleadings is appropriate when the moving party has clearly established that no material issue of fact remains to be resolved, and the party is entitled to judgment as a matter of law. Okay. The 10th Circuit Court of Appeals, that's you can totally quote any of these cases as long as it's from a controlling court. Generally speaking, I would look for, courts that are, within Utah, but it still carries the same weight. So don't worry about it. It says a motion for judgment on the pleadings is treated as a motion to dismiss under Rule 12b-6. And let me change. Actually, I'm going to leave that one how it is. And therefore, dismissal is appropriate if the complaint fails to state a claim to relief that is plausible on its face. As explained below, plaintiff's complaint fails to state a claim for relief. Let me get here. That is plausible on its face. As a result, the court should dismiss all of plaintiff's claims. Okay? How are we feeling so far?
Sounds good.
Pretty good.
Yeah. And I apologize. I'm deep into here, so I'm not seeing if there's any questions.
No, I'm paying attention.
Okay, cool. Yeah. And we might actually have to do this in a 2-part because I know we're coming up on an hour, but or I might just finish this out and just get it to Adrienne so she can get it and then we come back to it. But essentially what we're going to do now is we're going to break down, we're going to say here, I'll go back to the document and let's just talk about brainstorm here real quick. What were the major issues that we noticed? I'm going to come right here and I'm going to put in a bullet list. Let's go numbered, and then let's go this. Okay.
Well, the injured party is not making the claim.
Okay, so there's no real party in interest. There is no real party in interest. Okay. What's another major issue that we saw with this? Do I need to pop the, let me stop sharing that one and I will bring the other document back up.
I mean, I say no proof of contract, but that's kind of one and the same with the real party, isn't it? Or is that different?
Whoops, that's not the right one.
No evidence of contract with.
Oh, there we go. There's no evidence of wrongdoing. Is it This one. Yeah. Why is it still bringing this one up? That's not the one I want. This is the one I want. Yeah, okay, cool. All right, so number one is the real party in interest. So we said that. There's no real party in interest. Number two is we don't even know if Synchrony Bank is aware of this action, but we can actually put that within the real party of an interest. There's no evidence in support of plaintiff's claims or affidavits. Can you guys believe that again? Affidavits?
Oh, there's no
evidence.
affidavits accompanying this?
Nope.
Mm. Is anything notarized?
Nope.
Oh, this is
No
just-
evidence or affidavits.
They're using the courts to bully you and just hoping that
Mhm.
It's an ambulance chaser, so to speak.
Yep. So there's no evidence or affidavits in support of plaintiff's claims. Let's see if we can find 3 issues. So we talked about,
Would the fact that it was charged off be one of these issues?
yeah, it could be. That could fall under the evidence. So essentially what we would do is we're going to create our bullet points, the main reasons why the complaint fails to state a claim for relief. So we talked about there's no real party in interest. So that's one bullet point, and we can do sub-bullet points under that. There's no evidence or affidavits in support of plaintiff's claims. So there's that. And then the last one is...
So James, if they're stating it's been charged off and they're stating that they assigned it to someone else to collect, then they're double dipping.
Mm-hmm.
So there's insurance fraud. Well, I guess not if they're not getting the money back themselves, unless some of it does go back to them. I don't know.
well, then the insurance company could file that complaint, right? Because
Right.
they're the only ones who would have the standing for
That's
that.
a whole different case, though. That's
Right.
Yeah. So
But
here's what
it
I'm...
doesn't mean they're not double dipping on the original contract.
Exactly.
So
Exactly.
if you sold it, number one, you got money for the sale. If
Yep.
you charged it off, number two, you got money from the insurance company.
Mm-hmm. So
That's
the
clear.
contract has been satisfied,
Yes.
right?
Yes.
So here's what I'm thinking as far as the main bullet points for this. So let me open back up that. So what I'm thinking, there's 3 main bullet points. The first is there's no real party in interest. Okay. There's no evidence or affidavits in support of plaintiff's claims. And finally, plaintiffs have failed to invoke this court's subject matter jurisdiction. Right?
Okay.
Because anytime a complaint is filed and the court lacks subject matter jurisdiction, it has no authority to do anything.
Right.
Without testimony from a competent witness testifying to injury in fact, there is no subject matter jurisdiction.
And
This
that's
stupid...
due to the lack of affidavit.
Exactly. So they would need to invoke. Now, I'm not saying that they can't invoke. They can still invoke the court's jurisdiction if they bring someone from one of the plaintiffs. So somebody from Portfolio Recovery Associates would have to come into court and testify under oath or on an affidavit and state, yes, we had a contract with Adrian. Yes, she failed to perform her duties of that contract. Okay. And as a result, we suffer damages. So essentially their cause of action here is a breach of contract. That's what they're trying to come after her for. But in order for a cause of action breach of, in order for a breach of contract cause of action to uphold, the moving party must, 1, first establish that there was a contract between the 2 parties. Number 2, that one of the parties failed to uphold their duties or obligations as a result of the contract. And 3, as a result of that, the other party sustained physical or actual damages that they can prove.
Right.
I see none of that here.
No.
So,
And I did mention in previous videos, but if anybody has not seen those videos, that simply stating that over the phone about please provide me with the contract ends it then and there. And one of the biggest companies in America called American Express sent somebody after me. And that's all I said to them. I said, do I have a contract with you? I don't remember signing a contract with you or agreeing to anything. So
Yeah.
therefore, we're not in business together. Don't call me
Yeah.
again. They never called me again. American Express got it back, and American Express is the ones that called me. So often they're big enough to know that that is the law. So some of your smaller companies might just continue to hound you, and you have to get it to this point,
Mhm.
sadly. But it's always a great first line of defense is just ask them to provide the contract that says you have to
Mhm.
pay them. So
Yep, and that's the truth. So anyway, so that's what I'm seeing. I'm seeing that because they have failed to support their claims with verified evidence or with affidavits testifying as such, they haven't invoked the court's jurisdiction to do anything. So, do you think the court is just going to notice that and just say, "Oh, this court's dismissed. This case is dismissed"?
no.
They should,
Yes.
but they don't.
Right.
Because again, courts don't do anything without somebody moving them to do it.
Mhm.
Right.
And that's what a motion is. A motion moves the court. So we're asking the court, hey, I'm asking you to issue a judgment on the pleadings. Here's the rule that allows it. Here's a brief introduction. Here's the argument why it's appropriate. And then here's the reasons why. And then at the end, you're going to put a conclusion that'll state something, it'll say it's called a wherefore clause. Wherefore defendant requests this court issue this judgment for motion on judgment on the pleadings for the reasons listed above, blah, 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 blah. And then guess what Adrian's going to support this motion with?
An affidavit.
Oh my gosh, you guys are catching on.
Hey, James, if you have time, you can do this because we can separate this into two parts afterwards as well. So if you want to continue.
Yeah, I'd like to. However, I got to be honest with you. I work best if I'm just kind of thinking to myself because I do a lot of thinking out loud.
Okay.
I wanted to get the main bullet points, and then I'll come back and we can do a follow-up video to show you guys why I came up with what I did.
Okay.
So if that's okay with you guys.
That's great.
I did want to show, kind of the process. I wanted to let people know what do I do, when I need to write up a motion, when I need to write up a legal document, how do I do it? This is my process for doing that.
It's great.
So,
I think it's very helpful.
Okay. So the way we're going to round this, again, this doesn't need to be 15, 20 pages long. It only needs to be long enough to get your argument across, but just keep it short, simple, and succinct. And we're not going to be making statements of like, well, I have no contract with so-and-so.
Right.
Or we're just going to come back and say, well, I never had a contract with Portfolio Recovery Associates. That's an opinion. You're going to state things that are facts, like defendant is not now, nor has she ever been, in receipt of any documentation which would prove that she has a duty owing to or an obligation owing to Portfolio Recovery Associates, because that's a fact. So can they prove otherwise?
No,
they can't. They're not going to come into this court and say, well, here's the contract, because it doesn't exist.
Right.
So that's the first thing. The second thing she's going to state is as a result, they have failed to invoke this court's jurisdiction and they have violated Rule 17 as there's no real party in interest. And because of that, there's no controversy before this court, and because there's no controversy, this court has no claim that it can grant relief. Make sense?
Mm-hmm.
So that's how we'll do that. And the second one is like there's no evidence or affidavits in support of plaintiff's claim. Plaintiff was served to complaint on such and such day or time. However, there was no supporting affidavits or any evidence to verify and invoke this court's jurisdiction over these claims. In fact, defendant has no clue what any of these claims are or what this alleged account is in reference to. Because that's the truth, right?
It was at the time, yeah.
Yeah. So, I mean, you can state if you want to, plaintiff has done her due diligence and she did find an account. However, that account is not with Synchrony Bank. That account is not with anything, any of these names. And you can state that as long as it's the truth. Because again, your affidavit's going to say everything in here is the truth as well as I know it.
Mm-hmm.
Okay.
So what bank is that account with?
I believe it probably was through Synchrony. The company was Amazon. So if Synchrony deals with the Amazon accounts, then it was with Synchrony.
Okay.
But the only reason I know it's from an Amazon account is because of what they told me verbally when I called. So all the information I've had is from verbal information.
So banks, Amazon is offering banking services now?
Yeah, it was one of those, sign up, get $50 off your order thing. And at the time, I'm like, all right, cool.
Oh, so is it Amazon credit card?
Yeah.
Okay. Yes, often they have a different forward-facing name.
Yeah. So I know Synchrony backs a lot of these company credit cards.
Yeah.
So it's, but you go onto the Amazon site and that's who you pay. That's where you do everything. So
Yep.
it is very big possibility that Synchrony is the bank.
So again, the way you would know that is, did you receive any statements that had Synchrony Bank's name on them?
Not that I know of, but like I did everything online.
Okay.
So,
but like when you received statements from Amazon, it came like it was as if it was from Amazon, right?
yes.
Okay.
The
So
envelope said Amazon.
So it said Amazon, and so you had no reason to believe. I mean, I'm sure if you went and looked at the fine print, you might be able to find that the underlying bank is Synchrony. But again, if that wasn't disclosed to you, then you're not. How are you to know?
Yeah.
So,
and again, it was all online, and that terms of agreement, Synchrony could have been in the fine print at the, in the agreement as well.
Yeah.
So.
Oh, so they do Sam's Club as well. Yeah, I mean, Synchrony does. You guys, they do so many different consumer credit lines and
a lot. They do the care credit, the medical stuff.
Care credit. Yep.
Yeah, they're all over the place for these things.
Yeah, that's not uncommon.
But
so I'm just saying we need to be careful because it's not uncommon. So like one of my banks is an investment bank called Fidelity Investments. But if I do any transactions with Fidelity or try to do an ACH, it shows up as UMB Bank.
Yeah.
Mm-hmm.
So it doesn't necessarily mean it's illegal. It could be trickery and sneakiness, but there's a fine line.
Yeah, and this is where I'm saying is like these are the things that just you have to scratch your head and you're like, where is this coming from? So again, all we're going to put in this document here is the facts as we know it, the undisputed facts as we know it. So again, we're not, according to the plaintiff's complaint, this is what it is. We're not disagreeing with that. Now you did put you denied in your answers, but since that, you're like, okay, well, taking that information, we're going to go ahead and just re-spit it out here. And I might actually take each one of their claims and put it in here and state as, based on the information here, plaintiff's own complaint states that this is the real party in interest. And we'll talk about how, Synchrony more than likely isn't even aware of this action. So,
in fact, when I called to pay them off, once we were back to work, they said they had already charged off, and there's nothing that they could do. They didn't know where it went. They couldn't call it back. It was over.
Yeah, so we can put that in the complaint. We can put that in this motion as well because that's a fact. And you're going to state something in here that says defendant. After it said charged off, it say in fact defendant. Maybe we tie it back to saying defendant had an account with Amazon that had this last 4 number was the same. But again, has no proof that this was from Synchrony. However, when defendant called to pay the account off, they stated that it had been charged off. They could take no payment and they had no idea what happened to it. So there you go. Okay. So I will finish this up here in the next day or two. And then number one, Adrian, I'll get it to you and then we can do a follow-up on this next week. To see how it works. And then we're going to talk about how to really stick it to these guys because there's 2 different ways you guys can do this. You can just file a motion for judgment on the pleadings, or you can file, a motion for judgment on the pleadings or a motion to dismiss along with a counterclaim. I'm of the opinion, this is just my opinion, I don't want to file a counterclaim in the same court that they're bringing their action in. I want to take it in a different court. Now, the situation is because, Adrian, you live in Tooele County, you can file this action in Tooele County, or What I would rather you do is file a RICO case against them in federal court, because RICO cases are much stronger. You've got clear proof here. In fact, this is a court filing, so you can actually use their documents against them to state that they knew that these were false claims, and yet they still tried to collect it from you anyway. In fact, they tried to invoke a simulation of legal process in effectuating their fraud. Okay, so you're entitled to actual damages and treble damages, treble those damages in addition to punitive damages, whatever the court determines. So at the end of the day, this $1,100 or whatever it is they're trying to get from you, this $1,176, more than likely is going to turn into somewhere right around, I don't know, $50,000, $60,000 against them, maybe more than that.
Sorry, I shouldn't laugh at that, but yeah,
that's the only way this madness stops.
Right.
So
they
this
make millions per year based on the information I found. It's like 13 million per year is what they're making.
Yeah,
doing this to people.
Oh, this law firm did?
Yes, just this law firm.
Oh, perfect. Then we're going to go for a lot more than $50,000 or $60,000. We're going to go for a lot more.
They are interstate. They have things broken up, so it's hard to find information. Like this law firm, they know what they're doing, and they're a mess.
Well, they think they know what they're doing. So here's the deal, right? So since they're interstate, even better. Title 18, 1961. Those are the RICO statutes under the federal law. Racketeering, influence, corrupt organization. So they sent you something through the mail. They tried to effectuate. They said that you had a duty or obligation to them. They stated it was a security. Yeah. We're going to go after these guys for RICO, and they're going to be crapping their pants when they slap them. Because that stupid attorney who put his name on here, let me find that document again. Sean Umipig, Mr. Little Piggy. He that's a terrible name. Anyways, he's going to be one of the named defendants, as is this other guy, this Sean Morrissey, whoever he is. He put his name on here. You're a named defendant, dude. As is the Johnson Mark LLC, as is Portfolio Recovery Associates LLC. Yep. Those guys are all going to be named defendants, and I'm sure they're going to try and fight this as best they can, but they're going to lose. Because again, they were stupid enough to file a case in court.
Right.
That's public record.
Right.
So
that's bold right there. I mean,
mm-hmm.
they're just counting on the fact that Adrian had no idea about anything, mm-hmm. just going to go along with it and be bullied right into it. So good.
Yeah.
And it worked. If I hadn't posted in Telegram, like, hey guys, I need
There's
to show
a reason they're millionaires.
Yeah, seriously. I wouldn't have known. Yeah.
Well, this is what we want to do is we're tired of these bullies. Like, isn't this what's going on in our kids' schools right now? Where they're aren't they asking us, to stop bullying? Bullying is a problem. We need to stop it, right? Isn't this what's going on? I mean, I was just on Tuesday. My son, he's in 5th grade. We went up to a field trip. Speaking of, Justice is talking about. Ironic enough, the investigator's calling me, Justice. So I have to call him right back as soon as we're done. Anyway, they went up to it's called the Environmental Center that's up here in northern Utah. I don't know if you've heard of it, Adrian, but it's owned by our local school district, and they have classes that go up there during the winter, during the spring, and the summer, and they do all sorts of things about the nature and stuff. Well, anyway, we get up there, and I walk into the lodge there, and there's signs everywhere that says "Stop bullying." If somebody is bullying, go tell a teacher, go tell your parent, go tell a friend. So why are we allowing these law firms to do this to us? If we just sit back,
kids, not adult on adult. A bullying only seems to apply to kid on kid. They don't seem to apply to adult on kid or adult on adult. Yeah. And it needs to stop, and it stops now. And it stops because when people like you, Adrian, fight back, not only are you going to get this case dismissed, you're again, like I said before, you're going to file your own lawsuit, and you're going to go after them. Now, again, that's only if you want to, and if you want to, I'm willing to help you with that because it's fun. It's fun throwing this back in these people's face. Let's do it. It'll give me a
Yeah, well, it is. I mean, but it's a full-time hobby, right? Because there's a lot of things involved with doing this stuff. So
Yeah.
If I get good at this and I can help other people, I'm all about it. Let's do it.
That's
Amen.
our
That's what
That's
we're
our
all
goal.
about, right?
Yeah. I
hence
gotta
the justice revolution, because we want to hold the courts accountable. Period. It
being
says so in the Bible.
semi-retired is boring. Let's help people.
That's right.
amen.
Yep.
Amen.
Yep.
All right, you guys. Well, that's what I had for today. I wanted to go over that information there. I do want to touch on real quick before we end. What do you guys think about this craziness with the banks? You guys been following this at all?
Yeah. I think it's intended either
I do too.
either the good guys or the bad guys. I'm going to err on the good guys, and this is the end
Mhm.
to the Federal Reserve.
Yep.
Because I try to live with the glass half full.
Mm-hmm.
There's just way too much over the years. Even the military intel from the Q posts and stuff, so much of that has already come true. Whether you want to believe it in or not, it's already come true. It gave us the pathway for those to see, to hold on to society so people don't panic. And
Yep.
I see it as a good thing. They're trying to scare people by saying they're going to bring in the CBDC and all that stuff. Well, we're smart enough to just barter with people again. We don't have to use the CBDC, you know? So
Right.
Mm-hmm.
that's my belief personally.
Well, and I would agree with that statement. I'm pretty sure that's exactly what's going on, right? What have they been seeing? What are they pushing us toward? Electronic, 100%. Electronic cars, electronic currency, all of these things, right? Well, I mean, how difficult is it if you do something that's deemed inappropriate? How hard is it to shut any of that stuff off? It's not. It's not.
Nope.
So, what I see, and this is just, from bits and pieces of the information and stuff that I follow, what I'm seeing is, like you're saying, the end of the SWIFT system and the ushering in of something along the lines of a quantum computing financial system. A quantum computer can do trillions of transactions in a second. I mean, it's mind-blowing what it can do. But what I see is fascinating is we haven't seen anything like what's happening now. I should say this country hasn't since 1830. Do you guys know who was president in 1830?
No.
Andrew Jackson.
Andrew Jackson, I got it right.
Yeah, you got it right. Yep. He said, when you get in debt, you become a slave. He's not wrong.
No.
He's not wrong. Now, let me just back this up. I've got no love for Andrew Jackson. He was a racist. He was a slave owner. I got no love for the guy. However, he did take on, at the time, there was a big push for a central bank of some kind. He took on that fight, and he was the last. Can you guys believe this? He was the last president that paid off our national debt.
That's
Can
great.
you guys believe that?
Yeah. So the history of slaves goes back to the white population as well, and the Irish as well. And honestly, if you owned a slave today, it would be different. We're all slaves actually in a different format, but at least we came out of it. It was the thing to do. It was, is to have help with your plantations, and obviously the population was much smaller. So
different time that it was, but again, there's, like I said, I mean, this is not the forum for this discussion. I just wanted to touch on what's going on with the banks. I truly believe, just like you said, Justice, this is the necessary step to dismantling the Fed. You guys know that the Fed controls all of our money. All of our bank notes are printed by the Fed. It's not printed by the Department of Treasury. It's printed by the Fed. The Constitution allows Congress to coin money, right? So that's a power they can delegate, but it's not a power they can delegate to a non-government association or corporation, which the Fed is not part of the government.
Right.
Yet
or the CDC or the WHO.
Or any of that stuff. So, crap, we got to be careful. We might get banned. I keep forgetting about this stuff. You got to cut that out.
No, I know. Well, we didn't talk about the, what. That's
that's true. That's true, and we're not going to for at least for this discussion. So,
yeah.
all I'm going to say is guys, be diligent. I'm with you, Adrian. I'm excited about what's happening. There was a video. What the heck is his name? He's one of the guys that's on the Shark Tank.
Oh, I saw that.
What's his name?
I forget. The bald guy.
I can't either.
Yeah.
He's the bald guy, but I can't remember his name. And he was on like CNBC or like one of those financial type. And he was like, you know what? Good riddance. If you guys are going to be stupid,
yeah.
you know who I'm talking about?
He's like, yeah, let him go down. Bad management. Let him be the poster children for it. They shouldn't
That's
have
right.
done it.
Right.
He's like, that's right. He's like, no more of this too big to fail stuff. He's like, no more of this too big to fail stuff. This is United States. We live in a capitalist economy, and if they choose to run their bank stupidly and make stupid decisions, then they deserve what they're getting.
Yeah,
and I
no
agree.
one else is getting bailed out. And it's interesting to see the ties to that bank, which is all the big tech and Hollywood, and that's pretty interesting.
Yeah.
Party donations. Yeah.
Yep. $73 million to an organization that shall not be named. You guys can look it up.
Yep.
And I'll just say it's not the Bureau of Land Management. Let me just say that.
Okay.
So
can I share something, James?
Please do.
Since Adrian brought it up about, and the premise of the Justice Revolution is to change the courts and to change and to take back our power and to hold them accountable. It says so in the Bible. We quoted, there's numerous scripture on it, but we quoted the one we like the best because it's kind of what we do at the end, in our closing. Well, we put it on a t-shirt and I just wanted to share because James takes no money. He's helped so many people. He continues and he takes no money. But I have had people say, well, can we donate? We want to contribute because there's nothing we can do. We don't know how to do this stuff. We don't know how to give the advice or whatever. So I did create a few things, and I mentioned it once before, a buy me a coffee account for James if somebody felt like doing that at any point. But we thought this was fun, and you'll see us wearing these soon. So I'm going to share my screen, and we created a t-shirt because people like it. And on the back is the statement. On the back is the statement to show people that
your screen's not sharing yet if you're
all right. Can you see it now?
Nope. Give it a second here. Let's see.
Hold on.
There you go. It's coming.
Okay. Oh,
okay. There we go.
So you can see it?
Mm-hmm.
Okay. So just some t-shirts on an Etsy store, the Justice Revolution, and not every one of them has this on the back. It's two-sided. But, if you wanted to make a statement, right? Hate evil, love good, maintain justice in the courts. Those are the groupies of people that really are fighting back in the courts and fighting back pro se and things like that. So I just wanted to share that if anybody felt like it. I'll post the stuff in the Telegram chat, and I think it's in the pin at the top. But
it's on Etsy?
It's on Etsy, yep.
And it's
Etsy.
Justice Revolution is your shop?
Uh-huh.
Yep.
Okay.
So we just decided, girls, boys, and then of course we had to do this because we all know God only wins. Oh yeah, and I did do a little.
Oh, a mug. A camping mug. Yeah, very cool.
Yeah. But so if anybody felt like making a statement, because we just love the statement, and it's not just us, it's a biblical order. Maintain justice in the courts, and that's what we're trying to do. So So anyway.
Awesome.
I just wanted to share that.
Awesome. Thanks, Justice. Appreciate that. So
yeah, you're welcome. You work so hard, and
I do what I can. I do what I can when I can.
do a lot. And
I direct a lot of people to you. I'm like, hey, listen to this guy. And I've got that. Everybody so far has been like, this guy is good. I'm like, I know.
Awesome. I appreciate it. Well, if there's anything I could ask for, again, like Justice says, I don't want money. I'm not asking for money. I don't need money. I'm doing this to educate my brothers and sisters all across this great country of ours, and really all across the world. We have friends of ours north of the border up there in Canada that listen. So if there's one thing that I would ask of all of you is if you're watching this video, give it a like wherever you are. If it's on YouTube or if you're on Rumble or if you're on Facebook, wherever you find us, give it a like and then share it. We'd love to be able to grow our audience so I can get more information out to more people because we're going to have some really good stuff we're going to talk about. Like, Erica's mentioned earlier, at one point we'll talk about taxes.
And
about what
trust.
to do. And trust, and talk property taxes. That's a big one.
Mm-hmm.
That's a fight that I'm going to be having this year at some point where I live. So we're going to be talking about all of these things. And so like the videos, share them on wherever you are, Instagram or any of those other platforms that are out there. We really appreciate it. Likewise, if you're listening to us on any of our podcasts, and go ahead and hit the subscribe button. That helps to get more people listening, more people involved. So do what we can. Go ahead. Well, I'm sorry. What were you going to say?
Helpful people in the Telegram. So just James has
There
taken
are.
on so much, and he works full time, and he has a large family. So just be patient. And I know some people direct stuff towards me, and I'll tag James on it because I don't have an answer for you. I'm in the learning process too, and James is, he's like the expert. Erica's the intermediate and I'm the beginner, so we all have a different level of understanding, but that makes people feel comfortable because they can identify with my knowledge or Erica's knowledge and stuff, which is kind of why we do it. But just be patient. Just be patient. And there's a lot of helpful people in there from other law groups as well that pop in.
Yeah.
So,
Anyway, we love you guys. Thank you so much for listening. Again, give this video a like, give it a share. We really appreciate you all. Next Friday, we will do a follow-up again. And then I'm going to apologize ahead of time because there's coming up. I'm going to be away out with my family for a couple of weeks. So we might not be back for a little bit, but we'll figure it out. So for now, signing off, you guys. God bless you all. Thank you so much for listening, and you all take care. We'll talk next week.
bye all.
Thank you. Have a good weekend.